As you know, Amendment 5 says that government may not take private property except for public use and if it pays just compensation. Now, just compensation is a complicated area of the law. We'll get into that a little bit later. But what is a public use? Anybody? A park. Yes. A schoolhouse. Good. Highways. All right. You could probably come up with a pretty long list, right? The one thing we know for absolute certain about the public use clause is it's not a private use, right? That's the only thing that's absolutely unambiguously clear about the public use clause, okay? So what was it that the framers were trying to do when they wrote the public use clause? Well, you know, the founders had something that a lot of us lack nowadays, and that's political philosophy. And they had read the works of the great Whig thinkers like John Locke, and they had this vision of government as being constrained by certain natural moral laws. See, Hobbes and other philosophers had said, if there's no cop around, there's nothing wrong with going around and beating people up and taking away their stuff. Because law is just the dictate of the sovereign. That is what law is. There's nothing more to it than that. And so nothing is unjust without somebody there to declare what shall be just and unjust. So if the cop isn't looking, nothing is unjust. Locke rejected this. Locke said that nature has a law to govern it, and reason is that law. And reason teaches us that we shouldn't take things away from people for our own aggrandizement, or beat them up just because we don't like them, and that sort of thing. Well, the founders agreed with the Lockean position, and they announced it in the Declaration of Independence, among other places. For example, if you look at the Declaration, at the end of it, it says, it talks about how the United States are free and independent. It says, as free and independent states, they have full power to levy war, conclude peace, contract alliances, establish commerce, and do all other acts and things which independent states may of right do. May of right do. Not all things that independent states may do, but all things that free and independent states may of right do. That's only one example of the many times that the founders referred to the concept that moral law limits what government can do to us. Because I don't have the right to go and beat you up and take away your stuff. I don't have the right to ask somebody else to do that for me. So I don't have the right to ask my representatives to beat you up and take away your things. Right? So morality places certain natural limits on what government can do to us. So they kind of envision government like a bank guard, right? If you imagine you own a bank, right? You know, you're afraid that somebody's going to come in and steal the money from the bank, so you hire a guard to stand in the corner of your bank with a badge and a gun, and now you've got, problem solved, right? Except you've got one little problem. Now you've got a guy with a gun in your bank, right? And he could very well take out his gun and rob the bank himself. And so that's why you institute certain systems to protect the people. I'm sure you've all got your Federalist Papers with you, right? And you've read Federalist 51? How many of you have read Federalist 51? Okay, those of you who have your hands down, go home and read Federalist 51 tonight. You don't have to read the rest of them. Okay, I'll make that bargain with you. You can read the rest of them when you get to the law school, but you've got to read Federalist 51. I know that 18th century language is sometimes kind of tough, but you can get through it, believe me. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. So you have to create certain systems to protect people from the government. And of course, those are checks and balances, the Bill of Rights, institutions like that protect us from the government. And why do we do that? Why do we want these things to protect us from the government? Because later in Federalist 51, Madison says, in a society under the forms of which the stronger faction can readily unite and oppress the weaker, anarchy may be truly said to reign as in a state of nature, where the weaker individual is not secured against the violence of the stronger, right? The whole point of having a government is to protect us from bullies, right? But the problem with that is that bullies, sometimes they're smart, and they can figure out how to gain control over the government and use that to be bullies, right? And we call that, in modern parlance, we think we're so fancy that we invented all this stuff. We call that the public choice problem, and you've all heard about public choice so far this summer, I'm sure. Of course, Madison called it the problem of faction, but basically it's the same problem. The problem is government has guns, and people want to use those guns to enrich themselves. So they invest time and money in getting control of the government to do that. And the founders tried to find ways to prevent that from happening because it violates natural justice. Now, all of these ideas were thrown out the window beginning in about the 1880s by a group of intellectuals who were known as the progressives. Now, the progressives had basically four big ideas. First one was rights are just permissions, right? All this talk about the rights that are endowed by our Creator, it's just a bunch of rhetoric. We all know that rights are just permissions that are given to us by the state and can be revoked whenever the state decides that doing so would be in the best interests of the majority, right? And the greatest example of an intellectual who believed this was Oliver Wendell Holmes. Now, there may be some of you who disagree, and I'm sorry to say it, but Oliver Wendell Holmes was, in my opinion, the second most evil man in American history, second only to John C. Calhoun, the intellectual godfather of the Confederacy. I'd love to talk to you all about that later. Holmes had this idea that rights are just permissions, and he said, for example, quote, "All my life I have laughed at the natural rights of man," end quote. Probably the best example of this is his dissent in Abrams versus United States. Now, you law students, and those of you who will be law students, will learn that Holmes's dissent in Abrams was the fountainhead of modern free speech jurisprudence. That what Holmes said in that opinion is where we get our freedom of speech. Well, when you read the opinion, one of the first lines in it is, "Persecution seems perfectly logical to me," end quote. But he goes on to say, well, we don't persecute people because it's good for society to have a debate, and so we let people have free speech, in order so that the majority can learn things, and that's why we have freedom of speech. But this whole idea of rights, they're just really just permissions. Okay. The second great progressive idea was government exists to make the kind of society we want to live in. Of course, the founders said government exists to secure these rights, right? In Jefferson's inaugural address, he says the sum of good government is one which shall restrain men from injuring one another, shall leave them otherwise free to regulate their own pursuits of industry and improvement, and shall not take from the mouth of labor the bread it has earned. Not anymore. No, government exists to make the kind of society we want to live in. And so the progressives came up with all these clever schemes for improving society. Eugenics, segregation, government control over the money supply, the Pledge of Allegiance, the peacetime draft, prohibition. And of course, they were the first to use the term blight to refer to neighborhoods that were failing to perform to an economic standard that the government wanted them to perform up to. Blight before then, of course, was a term for a plant disease, but the progressives viewed political society as being kind of like a living organism, see? And so the individuals were just cells who worked within that living organism, and it ensured that the living organism would be healthy, okay? So this idea that government exists to make the kind of society that we want to live in, as opposed to protecting our rights, was best put by another awful progressive Supreme Court Justice, Louis Brandeis, who said, property and other rights of individuals must be remolded from time to time to meet the changing needs of society. Don't you love that word, remolded? What a great euphemism for violated, right? We weren't violating your rights. We were just remolding them. See, when the cop beat your head in with the baton, he was just remolding your rights and your skull, right? Suzette Kilo's property rights weren't violated by the City of New London. They were just remolded to meet the changing needs of society. The third great progressive idea was the idea of judicial restraint. Judicial restraint, of course, is the idea that courts should stand back and do nothing when legislatures violate your rights. Now, I like to emphasize this point because, unfortunately, a lot of our conservative friends have absorbed this idea that it's good for courts to be restrained. And someday I'm going to make a poster of great moments in judicial restraint, right? What are the great moments in judicial restraint? Korematsu, right, where the Supreme Court said it was okay to throw the Japanese in prison camps in World War II. The government decided to do this. What did the court say? They said, we're not going to do nothing. We're going to be restrained and let the people's will have the day. Right? Plessy versus Ferguson, where the Supreme Court said, if the state of Louisiana wants to segregate people, it can go right ahead and do that. We're not going to interfere. Buck versus Bell is another one of the great Oliver Wendell Holmes decisions. And how many of you are familiar with Buck versus Bell? All right, good. Buck was the case where Justice Holmes, writing for a nearly unanimous court, one justice dissented without opinion, said that it was okay for the government to forcibly sterilize women without their consent. It was one of the few things that Holmes was really enthusiastic about in his life was eugenics. And so he was actually pretty proud of this decision, and he wrote in it, 3 generations of imbeciles are enough, right? If the government can draft men to fight in their wars, then the government can force women not to have children for the betterment of society. That's the idea of judicial restraint. As Holmes put it, if my fellow citizens want to go to hell, I will help them. That's my job, end quote. Now, Federalist 78 lays out what the federal judiciary exists to do, and going to hell is not one of the things. Right? Federalist 78 says that the point of having a judiciary is to protect us from the legislature. Why? Because what the legislature does is not the will of the people. They love to say this. They love to say courts shouldn't strike down the will of the people. Legislation that gets enacted and signed into law is not the will of the people. This is the will of the people, right? Legislation is only the will of a particular legislature at a particular time. And very often it conflicts with the true will of the people as expressed in the Constitution. So when a court intercedes and strikes down a law as unconstitutional, it is enforcing the will of the people. Whether you buy that or not, that is Hamilton's argument in Federalist 78, and Holmes's flippant response to that is just so much intellectual bullying. Okay, the fourth great progressive idea, I'll skip really fast by because we all hate it, that's the living Constitution, right? That the Constitution stretches and bends to meet the changing needs of the time. So those are the 4 progressive ideas. Rights are just permissions, government exists to shape society, courts shouldn't interfere, and the Constitution bends and stretches to meet the needs of society. Now these ideas were in the minority for a very long time until the 1930s. When they became enshrined as constitutional law in a series of decisions beginning in 1934 with Nebbia versus New York. And that is where the court invented what is known as the rational basis test. Now, the rational basis test is the test that courts use to decide whether a law is constitutional if that law affects property rights, economic freedom, or other so-called not-so-fundamental rights. Okay? Your right to travel is a fundamental right. If the government's going to deprive you of your right, that is, the right to travel to Washington, D.C. If the government interferes with your right to travel to Washington, D.C., its actions have to be, quote, narrowly tailored to advance a compelling government interest, right? Well, that's hard to do. It has to be narrowly tailored. It has to do a precise thing. And it has to do something really, really important, a compelling government interest. Very few laws ever pass what's called strict scrutiny. So very few laws are ever held constitutional when using that standard of scrutiny. But your right to private property, which is mentioned in the Constitution, unlike the right to travel, your right to private property is considered a not-so-fundamental right, and government can interfere with that so long as its actions are rationally related to a legitimate government interest. Okay? And virtually every law is held constitutional under the rational basis test. The rational, as Clint Bolick is fond of saying, there's only 2 things you need to know about the rational basis test. It doesn't have to be rational, and it doesn't have to be the basis, right? And I'm not making that up. If the court thinks that a legislator could have thought that the law was a good idea, it is constitutional under the rational basis test. Okay. It doesn't actually have to be a good idea, doesn't have to accomplish what it was intended to accomplish, just has to be something that a politician might have thought was good for the country, and then it's constitutional. Okay. So that became the law. It was implanted in eminent domain cases in Berman versus Parker in 1954. Spread again in Hawaii Housing versus Midkiff in 1984, and then it ruled the day in the Kelo case, where the Supreme Court said if the government's going to take property and transfer it to other users in order to improve the local economy, it only has to be rationally related to a legitimate government interest. Okay, and in practice, what that means is the court looks the other way, right? It's judicial restraint. The court closes its eye. That's why Lady Justice is blindfolded, because she's using rational basis scrutiny. She doesn't want to know what's really going on. If she could think that it might be possible that a politician thought it was a good idea, then it's constitutional. So that's all that has to happen in eminent domain cases. Now, I've used this term under rational basis. I've said it has to be rationally related to a legitimate government interest. What is a legitimate government interest? Anybody? Come on. What's a legitimate government interest? Public safety. Very good. Very good. Well, and you guys who haven't answered, you're right in a way. In 1987, in Nolan versus California Coastal Commission, the Supreme Court of the United States said, our cases have not delineated the standards for determining what is a legitimate state interest. Think about what that means. The Supreme Court of the United States doesn't know what government exists to do. After 200 years of American history, with the Federalist Papers and the Declaration of Independence to consult. They don't know what a legitimate government interest is. And if we don't know what a legitimate government interest is, what business do we have asking whether something is rationally related to it, right? If, say, painting my room purple is a legitimate government interest, then buying paintbrushes is rationally related to that, right? But if I don't know what a legitimate government interest is, how do I know whether buying paintbrushes is rationally related to it? I can't. Yet the Supreme Court thinks that it can determine whether laws are rationally related to a legitimate government interest without deciding what interests are and are not legitimate, let alone compelling, right? Why are they so scared of making that statement? Why are they so scared of coming out and saying this is and this is not a legitimate government interest? Anybody? Because if they did so, they'd have to admit how much stuff government does that's not constitutional, right? And where would all these bureaucrats work? They'd have to go find real jobs. Okay. So Kelo is simply a classic progressive decision, right? Kelo says, there's the big line, the line that does it all in the Kelo decision is when Justice Stevens says, economic development is a traditional and long accepted function of government. There's no footnote, there's no citation, nothing to back that up. I've read the Constitution, I've read the Federalist Papers, you will soon read the Federalist Papers. It's not in there, right? Yet he simply asserts it. So we've got a classic progressive opinion. We've got judicial restraint, living constitutionalism, government exists to shape society, and Ms. Kelo's rights are just permissions that can be taken from her when the government decides doing so would be a good idea. What have we seen in response to Kelo? Well, there's been a lot of talk about a backlash against the Kelo decision and new laws being passed across the country. Most of these laws are frauds that are designed to fool the voting public into thinking something's being done when nothing is being done. I would give it about 70-30, maybe 60-40 of how many laws are bad or worthless versus how many laws are good or worthwhile. I'll give you an example of a typical bad law. That's the one passed in Texas. Texas passed a law that said three things. It said you can't take private property for a private use. Well, that's nice, but the Supreme Court already said that in Kelo, right? It just said that everything the government thinks is a good idea is a public use. But they still said you can't take property for a private use, whatever that is, right? So the Texas law, that first part of the Texas law doesn't do anything because the Supreme Court already said you can't take property for a private use. All right, the second thing the Texas law says is you can't take property for a pretext to confer a private benefit on a private party. Again, Kelo already says that. And the third part of the Texas law says you can't take property to give to a private party unless it's blighted. And what does blight mean? Anybody? Come on, you got to answer these questions. What is blight? Sorry? Plant disease, yeah. Yes. Not economically advantageous, that's right. Yes. Exactly. Anything a politician says is blight, that's right. The California law on blight, California law sets out two lists of factors, and if you have one from column A and one from column B, the property is blighted, okay? One of the factors that was removed by our reform-minded legislature in this last session was lack of parking, okay? They took that out. Good for them. One of the factors that remains in place, however, is factors that substantially hinder the economically viable use of buildings. What does that mean? It means whatever the politicians say it means. And once they make that decision, what is a court going to do when it reviews that determination? It's going to use rational basis, and it's going to look the other way, right? So we've seen in California, we've seen these perfectly meaningless laws that tinker around the definition of blight and still allow any property that a politician doesn't like to be condemned through eminent domain. Florida passed a really good law. Florida passed the strongest eminent domain reform measure we've seen, which actually specifically says you can't take private property for private benefit to eliminate blight. But the day before that law was signed into effect, the city of Riviera Beach, Florida enacted an agreement with a developer agreeing to condemn 400 acres of land filled with residences and small businesses in order to transfer to that developer for private use. We went to court representing the property owners and we won. But nevertheless, it shows the kind of cynical things that are being done by city and state governments. Other than the blight trick, another big trick we're seeing in California a lot, I don't think that's going on in other states, but in California there's attempts to reform the laws to say you can't take owner-occupied homes to transfer to private development, but everything else is okay. Well, now, first of all, this reminds me of how every Lent I just promise to give up something I don't do anyway, right? They don't take homes through eminent domain for these transfers almost ever. Usually it's small businesses that are condemned, because where does redevelopment occur? It occurs in business areas, right? And you don't find homes in business areas. So you don't usually find owner-occupied homes like Suzette Kilo's being taken. Nevertheless, California condemned private property for private development 8 times as often as Connecticut, where Suzette Kilo lived, during the same time period. That is an out-and-out fraud, the whole owner-occupied homes thing. And of course, we've seen some states that say, well, we'll appoint a legislative committee to study this subject and to take as long as necessary for the public's interest in this subject to die down so that we don't have to do anything. Why do we see this failure? Public choice, right? What we're seeing is powerful lobbyists exerting their influence and control over the legislature at the expense of the vast majority because they anticipate so much return. It's classic rent-seeking behavior. We've seen primarily the Darth Vader of eminent domain is Costco. Costco loves taking people's property for private development, right? If you ever wonder how Costco brings you such low prices, it's because they don't pay for the real estate, okay? Costco has people who spend their entire time going to city councils and lobbying them to steal people's property and give it to them. I see everybody looking at this poor young lady back here. Does she own Costco or something? Are you Miss Costco? Yeah, well, not anymore. Actually, I was at a thing last year. I ran into Mrs. Nordstrom. I really did, Mrs. Nordstrom herself. And at that time, Nordstrom's was engaged in one of these cases. And they did pull back from it, and Nordstrom has never engaged in eminent domain other than that case. But at that time, I didn't know that. And somebody introduced me, Tim, this is Mrs. Nordstrom. And I immediately launched into my eminent domain spiel. You know, oh yeah, you're stealing some people's, because I thought they were joking. Man, I was embarrassed. So, of course, to make it up to her, I complimented her on her shoes, because it's Nordstrom, right? Okay, so these people spend their time going to city councils to lobby them to steal people's property. Whereas homeowners, you know, they don't have that kind of time and influence. That's why you see the skew where these kinds of cases tend to take place in poor minority neighborhoods, because they don't have the political influence to ask the government to protect their rights. That's why we have a constitution, right? So that we don't have to spend our time asking the government to respect our rights. We can go about our real business to be productive members of society. Okay, that's enough on eminent domain. Regulatory takings. Regulatory takings is a very important subject that hasn't been covered quite as much in the media. What are regulatory takings? Well, suppose the government only had to compensate you when they actually seized your land. You can immediately see the loophole, right? All they have to do is pass a law that says, we're not taking your land, you're just required to build a Costco on it. We didn't take your land, we don't have to compensate you, right? Well, so the Supreme Court for many years has said you can't do that. If the government passes a law that deprives people of the right to use their property, it has to compensate them, right? Now, you will hear in law school a very popular lie that says that that regulatory takings was invented in the case of Pennsylvania Coal versus Maine by Justice Holmes. No, it's not true. The earliest Supreme Court decision on regulatory takings, it was 50 years earlier than that, Pumpelly versus Green Bay. But in any case, there are 3 basic kinds of regulatory takings: Loretto, Lucas, and Penn Central. Now, Loretto is a case that says if the government passes a law that requires you to let somebody on your land that you don't want to, they have to compensate you no matter how minor the impact. In that case, the state of New York required a person to put cable television in. She sued, saying installing the cable on her building, 1-inch cable, was a violation of her property rights. And the Supreme Court said, yeah, you have to compensate her $1 for taking away her property by forcing her to install this device. Lucas was a case where the Supreme Court said, if the government takes away the complete economically viable use of land, then it has to compensate you. What happened in that case was the government passed a law saying you're not allowed to build anything on your land. And so the Supreme Court said, yeah, you're taking 100% of the value, have to compensate you, okay? Those are the two big categorical takings. Lucas, if government forces you to let somebody on your land, they have to compensate. And that's a permanent physical occupation. And that's Loretto. Lucas says that the government takes 100% of the value of your land, then they have to compensate you. Everything else falls under the Penn Central test. Penn Central test pretty much consists of flipping a coin, okay? Except that the coin has both tails. Right? The property owners always lose under Penn Central. Never has the Supreme Court ever compensated a property owner under Penn Central. The Penn Central factors consist of things like the impact of the regulation on distinct, reasonable, investment-backed expectations, blah, 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 blah. All sorts of words that allow the justices to say, yeah, we think it's okay to screw the rich. Right? And so they never compensate property owners under the Penn Central test. Now, in order to remedy this problem, let me take a step and say, we have these two categories, right? Lucas and Loretto, and then we've got the swamp where property owners always drown, Penn Central. So what we always try to do is say, well, this case falls under Lucas and Loretto. So of course what the Supreme Court does is come up with different ways of avoiding those things, right? So, for example, Palazzolo is a case that Pacific Legal Foundation went to the Supreme Court on. In that case, the government had taken 90% or 98% or something of the value of this land. The property owner owned land that he intended to develop would have been worth $3 million, was worth $200,000 instead, because they said he could build one house on it. Supreme Court said no compensation is due, because compensation is due only when 100% of the use is taken. So now, of course, what do the bureaucrats do? They leave you with a token worthless property interest in order to defeat your claim for any compensation at all, right? And then there's Tahoe Sierra. Tahoe Sierra was a case a few years ago where the rule was if the government takes 100% of the value of your land, they have to compensate you. And if the government takes your land temporarily, they have to compensate you. So, in Tahoe Sierra, we have a case where in the Lake Tahoe area, the government passed a law in 1981, a temporary law in 1981, prohibiting virtually all development in the Lake Tahoe area. By the time 2001 had come around, these property owners were tired of waiting, and they sued, and the Supreme Court said no compensation because it's just temporary. So, after Kelo, we saw a lot of people a lot of these interest groups are trying to piggyback the regulatory takings issue on eminent domain reform and say, while we're responding to Kelo, let's also do regulatory takings reform. Now, I'm a big property rights guy. I love the idea of compensating people for regulatory takings, but this was a very bad idea, and it lost because, of course, nobody on the left wants to compensate people for regulatory takings, right? They feel very sympathetic to Suzette Kelo, right? We have a thing going on with the left on Kelo, right? Because they hate corporations. They hate evil rich corporations, eek! And so they're on our side when it comes to eminent domain. But with regulatory takings, suddenly they're the beneficiaries. They love passing laws that say you can't do anything with your property because a speckled gnatcatcher lives on it, and they don't want to pay for it. So they deserted everybody who tied these regulatory takings protections in with eminent domain protections. So the only one that passed was Arizona. California, Idaho, Washington, Nevada, all of those states, that lost in the November election. So what we've got now are two states, Arizona and Oregon, that have new laws requiring compensation for certain regulatory takings. That's Measure 37 in Oregon, Prop 207 in Arizona. So far, nobody's been compensated. Prop 207 only passed in November, though, and I am soon to file the first Prop 207 case, so we'll see how that works. No doubt I will win. What are the arguments against compensating? Thank you. What are the arguments against compensating people for regulatory takings? Well, one of them is we can't afford it. Right? Government steals so much from so many people that we couldn't possibly afford to compensate them for it. That really is the argument. I mean, it really is. And if you read Tahoe Sierra, Justice Stevens says that in Tahoe Sierra. If the government were to compensate people for all of the delays and permit requirements and things, it would go bankrupt. Therefore, we don't have to pay. Wow, I wish I knew that rule when I was a kid. Then there's the argument, well, it's bad for democracy because it limits the ability of the voters to decide what other people can do with their land, right? This harkens back to the progressive idea that democracy trumps liberty in the Constitution. I think this is really worth emphasizing for everybody. The idea that democracy trumps liberty in the Constitution is completely off base. The Constitution doesn't exist to empower majorities. Majorities don't need to be empowered. They're already the majority, right? The Constitution is unambiguous on the fact that liberty is a blessing, right? We the people, right? It says the blessings of liberty. Doesn't say anything about democracy in there. The Constitution consists of several pages of limits on democracy. That's all the Constitution is limits on democracy, right? The idea that democracy comes first and liberty second is completely backwards. But nevertheless, it's an idea inherited from the progressives and seen today in property rights disputes. However, I would also say that compensating people for regulatory takings is good for democracy because it enables the taxpayer to make a cost-benefit analysis of its regulations. Otherwise, the taxpayer thinks he's getting all this stuff for free. Well, I like the view of that hillside, so I'll prohibit anybody from building a house on it. And it's free to me. I don't have to pay anything. Not really, right? We all know because of Say's law, social wealth decreases, blah, 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 right? But they think they can get it for free. If the taxpayer was required to compensate it for that, he'd say, well, you know, there are better uses for my money. And if it's really a good idea to get away with a simple majority rule on property rights without compensation, why not eliminate compensation for eminent domain also, right? It's also really expensive. It stands in the way of democracy. I hope nobody out there hears this because that'll be what they propose next. I wouldn't be surprised. Okay, and then the third big argument over regulatory takings that we're hearing a lot nowadays is givings. Givings. This is great. You guys have no idea how left the law really is. Okay, so the idea is when the government gives you a permit to build your property, it's giving you economic value. And therefore, you owe something back to the government. And you should really be paying the government for these givings. You laugh, you innocent people, you laugh. So when the robber refrains from breaking into my house, I owe him something. That's really the idea. Okay. Regulatory takings leads me to Nolan and Dolan. Nolan and Dolan are cases involving regulatory takings, a particular kind of a regulatory taking, which is increasingly common, where the government says, if you want a permit to build on your property, you have to give us something, right? Now, you and I would call that stealing, bribery, racketeering, right? No. This is wise land use planning. And now in Nolan, the Supreme Court said if the government is going to require you to pay something in exchange for a permit, that decision, there has to be something about the permit that has a connection to what they're asking of you. For example, if you want a permit to build a factory, the government can say, we'll only give you the permit if you put scrubbers on the smokestacks, right? Because it will harm the public to have the smoke drifting over. And so they can say, in exchange for the permit, well, because it protects public safety, which is a legitimate state interest, right? But, of course, the cities don't like that. What they like doing is saying, if you want to build such and such, you have to buy us a new city hall or something, you know. And they're getting away with this, even though the Supreme Court has said it's not allowed. In a case I'm doing right now called Ocean Harbor House, for example, some people own a beachfront condominium in California, one of the few. It was built before the California Coastal Act, which is why it exists. Their condominium complex is going to collapse into the ocean pretty soon because of the erosion that takes place at every beach. So they asked for a permit to build a seawall, and the California Coastal Commission said, that'll be $5.3 million, please, which is more or less the price of the condominium complex, you know? So that's the kind of stuff that we're seeing routinely. Of course, the trial court said that was okay, so we're on appeal now. Another problem with regulatory takings that I want to mention briefly is something called the Williamson County trap. This is something you don't really hear about in law school, but this is a nasty little trick the Supreme Court has ginned up for property owners that they don't impose on anybody else. If you're going to sue over a regulatory taking, the city has passed some law that restricts your right to use your property. You have to go to state court first. Not allowed to go to federal court. Now, this is important because we all know that the county judge is the brother of the mayor, and they're not going to rule in your favor. State courts, in California, state courts never compensate. It just doesn't happen. They do not compensate property owners for regulatory takings in California. So you have to go through the state court system and then hope that you can get certiorari out of the state Supreme Court to the U.S. Supreme Court, which takes 80 cases a year, to protect your property rights. Ain't gonna happen, right? But that is the trap. Now, if your rights to free speech were violated, if your right to freedom of religion was violated, you could race down to federal court. That's what federal courts are for, to protect you when your state judiciary refuses to. But in the Williamson County trap, you're SOL. I'm doing a case, speaking of permit requirements, this is my favorite case that I'm working on right now. I'm doing a case right now where the city said, if you want a building permit, you have to give up your right to vote. Now, people think I'm joking when I tell them about this case. In California, we have a constitutional rule called Prop 218, which says that if the government's going to assess your property, which means require you to pay for certain street improvements and things like that, assessments are different from fees, which are different from taxes, it gets complicated. But in any case, if they're going to assess your property, they have to have an election to form an assessment district. And then they have to give everybody in that district the opportunity to vote on whether or not to agree to this assessment, right? Well, the city of Carlsbad went to Craig and Robin Griswold and said, if you want a building permit, you have to either pay us the assessments up front, which is illegal, or if you can't afford that, sign this little document that says you're giving up your right to vote on property assessments, and it runs with the land to any subsequent owner of the property. Okay. I went to federal court. You can't believe these cases. I go to federal court. The city's attorney, the judge says to the city's attorney, well, if you can require them to pay this stuff up front, why can't you require them to sign a waiver? And the city attorney, that's right, Your Honor. We have the police power in this case called Ehrlich and blah, blah, blah. And when I got up, I said, Prop 218 was passed after Ehrlich. It limits the police power. And if the city didn't think that what it was doing violates Prop 218, why does its waiver form say, these are your rights under Prop 218 and you are waiving these rights? We're waiting on a decision from the federal trial court in that case. We've been waiting since June, then it got put off to July, now it's been put off to August. I'm hoping that's a good sign. Case that the Supreme Court decided last month called Wilkie versus Robbins is very troubling for property rights. That's a case where Mr. Robbins owned land in Wyoming. The government wanted an easement over his land. That's essentially permission to cross over the land. They wanted an easement from him, and so they said, give us an easement. And he said, no. And they said, well, then we're going to make life hell for you. And they revoked his grazing permits, and they revoked his easement over government land, and at one point, some government agents even broke into his lodge. They harassed his customers. They did all sorts. They brought a trumped-up prosecution against him for interfering with a federal officer. He was acquitted after less than a half an hour of jury deliberations. All this sort of thing. So finally, he files a lawsuit and says, "This is violating my Fifth Amendment right to say no to the government." Right? Supreme Court said, no, you can't bring these kinds of cases, because if you could bring these kinds of cases, it would deter zealous action by government officials. Here is some deterrence to zealous action by government officials right here, right? So, yeah, that one sucks. I'm working on a case right now, my raisins case. I love my raisins case. Okay, so, did you know that the federal government seizes sometimes up to half of the entire raisin crop of the United States? Every year. They seize a quarter and sometimes a half of the entire raisin. Why? Why do they do that? Anybody? Why? Exactly, to make raisins more expensive for poor mothers to buy for their children. Because that is what? That is a legitimate state interest. Right? This was a program, agricultural adjustment, was created during the Depression, right? When the idea was, well, if we throw food away, we'll be richer, right? I wish I were making it up, I really do. You've got to read this great book, Jim Powell's FDR's Folly. If you haven't read it already, I really encourage you to do so. It's a great brief book on the ridiculous ideas that were circulating among the Brains Trust an ironically named group, if anything, during the Franklin Roosevelt era. So what they do is it's called a Agricultural Marketing Adjustment Act, or Agreement Act, passed in 1937. It allows the Secretary of Agriculture to institute marketing orders, which state what the price of raisins shall be. It gets very complicated, but that's basically the way it works. So the government comes to you and says, we're taking, in this case, I believe it was 48% of your raisin crop. And the government then takes these raisins, sells them under a government brand name to public schools and other institutions like that, then takes the money from those sales and uses it to subsidize American farmers who sell raisins overseas so that we can undercut prices in those countries and further impoverish the third world. Then, whatever is left over after these sales is then returned to the farmers who had their raisins stolen to begin with. So a lot of these farmers finally got tired of this. They went to court. They said, this is a taking of private property. Where's my just compensation? And the Court of Federal Claims, right down there on Lafayette Square next to the White House, Court of Claims said, it's not a taking. It's a toll for the privilege of selling your raisins in interstate commerce. Now, how many things are wrong with that sentence? First of all, the idea that rights are privileges, again, there's a reason why we called it the fruits of your labor, right? You have the right to sell the fruits of your labor, even if they're shriveled up and covered with sulfur. I don't like raisins. But I love raisin growers, okay? And you couldn't possibly avoid selling your raisins in interstate commerce if you tried, right? We all know from the Rage case a few years ago that everything is interstate commerce. If these people sold raisins from a sidewalk stand to passersby on the street, they would be required to abide by these regulations. So that case is currently on appeal before the Federal Circuit, so we'll see how that goes. One last one. Case that my friend Lauren here will help me work on at PLF, Hernandez versus City of Hanford. This case has not received the kind of attention that it really deserves because this case is bad news. This case is kilo for zoning. What happened was the city of Hanford said, well, we're going to protect this particular neighborhood from economic competition. It's a business district, some furniture stores there. So they said, well, we're going to protect them from economic competition by prohibiting anybody from selling furniture elsewhere in the city. Okay, which of course does what? Raises prices for furniture, makes it harder to find furniture, harms the poor. And the city of Hanford ain't the richest city in California to begin with, right? Harms job creation. It's a stupid idea. But the city says, well, we're going to protect these particular businesses. Why? Because we like them, right? And the California State Supreme Court last month said that's perfectly okay because that's a public interest, right? As long as it's not a private interest, but a public interest, then it's okay to use zoning powers to prohibit fair economic competition. Now, what is the difference between a private interest and a public interest? We could probably talk a long time about that, but one thing we know is that we could never come up with an answer if we use rational basis scrutiny, right? If you're using rational basis scrutiny, all you ask is whether the politicians thought it was a good idea. Well, every politician's going to say his idea is a good idea no matter what, right? Well, my cousin works down at the Walmart, so I want to prohibit Targets so that Walmart will succeed, because I think that's good for the public. There you go. It's a public interest, right? This case is very unfortunate because it represents this merging of public and private benefits that we all knew was coming anyway, because if the government and private industry join together, all that means is public choice, rent-seeking, private industry using government's guns to get its way. Now, these are some of the current hot topics in property rights issues. The bottom line is that currently, under the rational basis standard that has been used in these cases, courts are systematically incapable of understanding what really goes on in property rights disputes. Now, I think that they know what's really going on and they're just lying. But if they're not lying, then we have to imagine that federal judges really think that city council members and state legislators only care about the betterment of the public and the protection of the public's rights and blah, 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 when we all know what they really do. They really see themselves as sculptors of neighborhoods who are able to shape society into the shape they think is preferable, and they use your property as the clay for them to mold into what they think is a good idea, and then they call it the vision thing, right? That's what vision means. Vision means using your rights for what I think society would look good. I mean, that's what Costco does, right? Costco goes to the city council, and the guy from Costco says to the city councilman, you know, if you tear down those people's properties and you give us that land for a Costco, we'll build this store, we'll get rich. You politicians will look like visionaries because you've created jobs and you've improved the local economy. And the only people who lose out are the sucker property owners, and they're only one vote. Who cares about them, right? And that's what really goes on. And unfortunately, thanks to rational basis scrutiny, we don't really have a handle on that in the judiciary. The second really important lesson is, without addressing the fundamental philosophical questions of that are involved in eminent domain and regulatory takings, we cannot hope to resolve these problems. This is not a problem of voting or adjusting a system or improving compensation, all these sorts of technical policy wonk solutions. This is a philosophical problem. The reason why eminent domain reform has failed is because there hasn't been enough of a solid philosophical defense of private property rights. I've said that the government, the Supreme Court of the United States, has said they don't know what a legitimate state interest is. Well, if you haven't solved that problem, we cannot hope to solve the problem of property rights and the rights of property owners in this country. So I'm leaving that up to you guys, you and me a little bit. Our job is to teach this country once more what a legitimate state interest is, to teach them again what it means to subscribe to the ideas in the Constitution, the blessings of liberty, or to the Declaration of Independence, right? We don't need to think too long to find a legitimate state interest, right? It's right in there. To secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That is it. There's your legitimate state interest. It doesn't exist in order to make sure that Costco is succeeding, or to ensure that the downtown furniture center is succeeding, and that to redistribute wealth, right? In Penn Central, the Supreme Court said that the government doesn't even have to compensate you most of the time when it takes your private property away to, quote, adjust the benefits and burdens of economic life. Adjust the benefits and burdens of economic life. I don't see that in here, right? That's not what this country was intended to do. It's not what the Constitution was written for. So I leave it to you to solve this problem, right? I'm fond of Walter Williams' famous line, "What do I care for future generations? What have they ever done for me?" Right? Well, you know, some of us actually do care about future generations. And I think that we have it within our power to make the world anew. So, thank you very much. I'd be happy to answer any questions you might have. Yes, sir.
Andrew Verdon, National Foundation for American Policy. I come from New Jersey, and one of the big issues right now is open space legislation. What's your take on that? And do you also feel that a lot of town councils are abusing this legislation in order to forbid businesses from building anywhere?
Oh, heck yeah. You know, open space used to be called idle, unused land, right? Just like rainforests used to be called jungles. In fact, if you read Locke, he says that one of the few legitimate uses for eminent domain is to take idle, unused land and put it to productive use. But now we've reversed that completely, right? Yes, of course, a lot of these laws exist, you know, and these people genuinely believe that they're beautifying the city and stuff. And, you know, a public park probably is a public use. But when they say, well, if you're going to get a building permit, then you have to provide us with open space, then what you have a problem with is you're leveraging the police power, leveraging the government's power to accomplish things without paying for them. And of course, the government loves doing that because the politicians don't want to raise taxes. So if they can get a few people with little voice to pay the cost of providing the government with a public park, then they're really happy because now I, the good politician, have provided this public park and it didn't cost you anything, right? So, yes, sir.
Chris White, the Mercatus Center. I have a question about the fundamentals of property rights. If you have a right to property, how is it ever justified to take it, no matter what the use is?
Yeah, I've played around with this idea myself. I haven't come up with a solution that satisfies me. I will recommend that you read Epstein's book, Takings, if you haven't. Epstein's view is that the government exists to secure individual rights, but it also has a legitimate place in forcing what he says are Pareto-optimal exchanges. Now, those of us who grew up Austrians think there's a contradiction there, because if it's Pareto-optimal, then you wouldn't have to force it, and if you're forcing it, it's not Pareto-optimal, right? But he claims that if the government forces people to engage in an exchange that makes them both better off, but that they're unable to do because maybe of transaction costs, then that's legitimate. And he's got an interesting point, because if you think about it, that's what the social compact is, right? The social compact is a forced exchange that supposedly is Pareto-optimal. But again, it can't be, right? Because an exchange is only Pareto-optimal if it's voluntary, and if the exchange is voluntary, then it's Pareto-optimal. I mean, there's no other way of measuring it. Yes, I know, Posner, blah, blah, blah. But my answer, because I still have a lot of trouble with that, my answer was to say that, well, you might say that there are cases where self-defense legitimizes certain takings, right? The common law has a certain rule in tort that says, for instance, if you're in the forest and it's a snowstorm and you're going to die and you see a cabin, you are allowed to break into the cabin and eat the food as long as you compensate the owner afterwards. Well, you could say maybe there's an analogy there for certain eminent domain cases where, in order for the government to protect the public, to build a fort or something like that, maybe that's analogous there. But I admit, I have a real trouble with the idea that it's ever legitimate to seize people's property without their consent. Yes, ma'am. I'm sure I can hear you.
We have to do it for the state.
All right.
My name's Allison Schmauk. I'm at Institute for Justice. I was wondering if you had read anything about the originalist understanding of the regulatory takings and public use clauses, i.e. what the framers would have understood them to mean based on English common law or whatever else in the drafting of the Constitution.
Yeah, well, first of all, I recommend that you read Pompelli. Pompelli was 1883 or something like that, and that was a case involving damage to private property that wasn't taking. And the court said, if we say that you only have to pay for actual takings, then that allows this ridiculous loophole. There was another case like 3 years later at the Michigan Supreme Court that said the same thing. As far as the founders are concerned, there are some very bad law review articles out there that claim that the founders never intended for regulatory takings to be compensated because they were all gung-ho for zoning. Well, okay, I exaggerate slightly on that last bit, but for instance, William Michael Traynor has published a law review article claiming that the founders never believed that compensation was ever due for regulatory infringements on private property rights. There are refutations of that article and others. I can't give you the titles of the authors, I'm afraid. You'd have to do a Westlaw search. I can't remember. But of course, you really have to remember that the land use regulatory state that we've got now was invented in the progressive era, more or less. I mean, zoning was first held constitutional in the 1920s, right? And these were schemes that didn't exist in that time. You had the right to build a mill on your land if you wanted to build a mill, and the only time it really was a concern was if it violated somebody else's rights, and that was dealt with by nuisance, right? What was the purpose of zoning originally? Anybody? What's the purpose of zoning as originally conceived by the progressives? To keep racial minorities out of white neighborhoods, right? I mean, that's what it was invented to do. And it's still used to do that today, although we don't like to talk about it. And of course, Justice Sutherland, who wrote Euclid, was normally a pretty good freedom-loving guy. What I think he was doing in Euclid was he was saying, look, zoning is okay only if it mimics traditional nuisance law by prohibiting people from violating each other's rights. And what's good about that is it means that zoning law should be interpreted by the lodestar of the right to use your property, as opposed to what it is used now in the Hernandez versus Hanford case of being the tool with which government shapes neighborhoods. I was in this meeting. Oh man, I get so mad about this that I love telling people about it. I was in a meeting last year with the California Assembly Republican Caucus talking about an eminent domain reform bill. And this guy gets up and he says, well, I'm afraid, this is a California state assemblyman. He says, well, I'm afraid that requiring compensation for regulatory takings will limit the government's ability to decide what businesses are appropriate for a neighborhood. And I couldn't help myself. I said, I thought consumers were supposed to decide what businesses are appropriate for a neighborhood. And he said, well, that's very libertarian of you. I get that a lot. But I said, excuse me, I remember we had this governor here named Reagan. You might have heard of him, Of course, that went nowhere. And now he's the chairman of the Assembly Republican Caucus. So. Oh, lots of hands, yes. I'm sorry, you calling on people? I was calling on people. I was stealing your job. Okay.
All right, Gary Zoney, National Center for Policy Analysis. You said that the Constitution was the will of the people, and that today's legislators are not. However, the writers of the Constitution were that day's legislators. So how do you draw that line? And with that, do you believe in the social contract? Is that where you're coming from?
I do believe in social compact. I believe that it makes a lot of sense to say the Constitution is the will of the people, and if the people wish to change it, they have the freedom to do so. And we have a system in place for them to do that. They can even change that system if they like to. But they haven't done it. I mean, it's really amazing to me. You read these works, especially during the Progressive era, where these people say, well, the reason we need to change the interpretation of the Constitution and eliminate substantive due process is because we can't possibly amend the Constitution, it's just too hard. Well, there's a reason for that, right? So that you won't do this end run around the amendment process, right? And so the answer is, the system is in place for the present generation to change the Constitution if they want to. And the fact that they haven't done that is strong indication that there are good reasons why these things have not been enacted into law, into the fundamental law, the constitutional law. Yes, sir.
My name is Terrence Watson from Citizens Against Government Waste. I guess I had another question about actually, first of all, I want to say it's good that you mentioned Hegel in your article. When you started talking about the progressives, that was great. Glad to see that in there. I'm a philosophy student, so yeah, I like to see Hegel stuff. Okay.
One of us.
There's got to be at least one person in the room. What would you say would be a viable defense of property rights? I mean, these days. I mean, do you still think that natural rights are going forward with people?
Absolutely.
Really? You don't think that they've kind of moved on?
No, if anything, it's the intellectual elite who think they're too good for natural rights.
Okay.
Yeah. If you were to tell the average American that the idea of natural rights is rejected almost unanimously in the American courts, they would be horrified at that idea. And of course, it isn't really rejected because even those who say they're really anti-natural rights end up appealing to it eventually, sooner or later. I would also recommend strongly that you check out John Marini's book, The Politics of Budget Control, which has some excellent stuff on Hegel and his connection to the progressives.
Interesting. Okay. What was the name of that book again?
It's called The Politics of Budget Control by John Marini, Marini. Yes, sir.
I'm Austin Dews from Cato. My question is kind of related to Gary's, I think, just in I'm looking for some clarification as to why there's a different standard now that we probably wouldn't use in 1776. Like, why is this sort of this idea of founder omniscience? Like, wasn't rent seeking happening back then? Didn't the founding fathers do a lot of things that probably wouldn't respect natural rights? Like slavery, for example, was left out of the Constitution, like bans on it, the Declaration of Independence, because people would benefit from it, people who were politically powerful. So how do we get around that when we have to appeal to founders' intent all the time, especially when we have other people saying, well, if the legislature's intent is what is important and what the judiciary is supposed to enforce, then how do you not contradict yourself when you then try to go to founders' intent, I suppose?
Boy, that is such a good question. I wish I had a pen so I could write down all the things I'm trying to remember to say. There is an article or two or several by James Buchanan arguing that the solution to the public choice rent-seeking problem is to require generality in all of the laws that the government passes, so that the government doesn't, so that the government doesn't take things from some people and give it to other people. It has to pass laws that are generally applicable, and we treat like cases alike. Now, that is what the Due Process of Law Clause was intended to do. The Due Process Clause, again, we run into problems with our conservative friends who think substantive due process doesn't exist, and they're just wrong about this. This due process of law meant government could not use its power simply to take from some and give to others. There's a great case on this, Loan Association versus Topeka, one of my favorite cases of all time, one of the first great substantive due process cases. And what it basically says is, if their government is going to take property from A and give it to B, that's not a provision that protects the general public. It doesn't have anything to do with the general public. It's just using its power for the benefit of a private group, and that isn't law. It's a mere enactment, because a law is a justified use of coercion, and a mere enactment is an unjustified use of mere force. An unjustified use of mere force, if it takes away your property, by definition, takes your property without due process of law, right? But if the enactment actually does protect the general public, then it's a law, and then it satisfies a due process clause. That's very simple. That's what Loan Association versus Topeka says. Well, unfortunately, there's a great philosopher named Anthony de Jassay. He's written a book called Justice and Its Surroundings, which is a hard book, but I strongly recommend it. He has a response to Buchanan, and that is, it won't work. Because if the public choice theory is correct, that rent-seeking minority groups will seek the legislation that benefits them, then it is also true that they will seek the Constitution that enables them to accomplish that kind of legislation, right? And so what you'll end up having is a gradual erosion of constitutional restrictions, which is exactly what we saw in 1934 in Nebbia versus New York and the creation of the rational basis test. So that's my first answer. What did the founders do about the public choice problem? They tried something, didn't work too well, but it's probably the best that can be done. As for didn't the founders experience rent-seeking? Yeah, absolutely. Of course, that's one of the primary reasons that they had the revolution, right? I mean, monopolies, real monopolies, not successful businesses, which is the definition of monopoly nowadays, genuine monopolies, government-created monopolies that where the government prohibits competition with an enterprise, were one of the leading concerns of not just our revolutionary generation, but the generation that taught them, which was the English Civil War generation, right? If you haven't studied the English Civil War, you don't understand the American Revolution, right? The American Revolution, the seeds for that were sowed, the seeds for libertarianism were sowed in the Whig revolt against the Stuart monarchy, and one of their leading complaints was monopolies. There's a great book Gordon Tullock published called, Mercantilism as a Rent-Seeking Society. Because that's what it is, right? Mercantilism is simply the government serving particular groups of traders by making it illegal to compete with them. I'll give you one great story. A case called Darcy versus Allen, which was argued by my hero, one of my heroes, the greatest lawyer of all time, who was Sir Edward Coke, who was the Attorney General for Queen Elizabeth I. And what happened in that case was the government had a law saying it was illegal to manufacture and sell playing cards because Mr. Darcy, I believe, or Mr. Allen, I guess it was, I don't remember who, had a monopoly on the manufacture and selling of playing cards. So the other guy went and made and sold playing cards, and it went to court. And the Court of King's Bench, 1602, I believe, said it violates the Magna Carta's law of the land clause for the government to pass these monopolies because under the law of the land, a person has the right to earn a living without unreasonable government interference. And that was popularly known as the case of the monopolies. And there are many cases like that in the 17th century that you will never hear about in law school. The only place you'll ever hear about it in law school is if you read Stephen Field's Dissent in the Slaughterhouse Cases or something. But otherwise, you don't get that kind of stuff. It was a traditional common law right to earn a living without interference that was designed to benefit insiders. Of course, that gradually went away with a rational basis test. As for slavery and other things, absolutely. I mean, the founders were certainly no angels. James Madison wrote some great notes before the convention in 1787, where he's what is it called? Observations on the defects of the constitutions of the United States, or something like that. Where there's a little phrase where he said he's talking about all the defects of the current political system, and he has a little note where he says, "Where slavery exists, the term Republican is even more fatuous." So, yes, sir.
I'm Andrew Stegmeyer. I'm with America's Future Foundation, and I know that one justification that municipalities often use to justify opposing costs on people that want to develop their property is that certain kinds of uses consume more municipal services than others. The most notable case is that residential tends to demand more in schools and other municipal services than it pays in taxes.
Yeah.
That strikes me as a pretty legitimate
Yeah, sure.
use. And you think there's a principled legal way to distinguish between those kinds of impositions of costs and other ones?
Well, I think we sacrifice principles when we have things like public schools, but yes, I think that what we've got now is kind of a mishmash out of the Supreme Court that says if the demand on the property owner has a nexus, a rational nexus with the impact on the public fisc, and if the demand is roughly proportional to that impact, then it's okay for the government to demand what it does. And that just means, we'll let you get away with most things, but things that are truly ridiculous, the government can't do. That does not stop them from trying. I think in the current situation, then yes, absolutely. If a developer is going to build 100 new homes, then obviously that's going to overwhelm the local public school. Yes, they can require that the developer provide funds toward constructing a new public school in the current system. But, this argument is very similar to the motorcycle helmet law argument, right? That's the argument that, we're going to create this government-funded public health care system. And I stand up and say, I don't think you should do that. And then they say years later, too many people are getting into car accidents without helmets, and they're causing us to spend a lot of money at our government-run healthcare system. Therefore, we're going to pass a law to require you to wear helmets. Well, but why don't you just make it so that you don't steal my money to pay for other people's health care? But nobody listens to me, right? So that's kind of the same argument. We're going to create a pervasive regulatory system that requires permits to practically breathe, and then we're going to say, what you're doing is imposing a severe burden on the local government. Says, that's your fault, government. But I understand we live very far from a free market world, and so the answer is, under the current situation, I think what you say is correct. Oh, come on. Somebody's got to ask about Calhoun, right? Yeah, so, ask about Calhoun? All right, tell me about. All right. You have a specific question, or you're just going to. Oh, man. Okay. Yeah. Man. Calhoun, for those who don't know, was a South Carolinian senator, also Secretary of War and Secretary of State, who was a popular leader of what became known as the Nullification Crisis of the 1830s, and he wrote a couple books. And the Nullification Crisis was the idea that states can interpose themselves and refuse to enforce certain federal demands, certain federal laws, if they believe that those demands are unconstitutional. If anybody else had suggested this, I would say it reflected a brazen ignorance of the way the Constitution actually works. But Calhoun was way too smart to be ignorant. Calhoun was simply evil. No, he really was. He believed that slavery was a positive good, that it was necessary for every society. One of my favorite Calhoun quotes is when he was talking about the Declaration of Independence, and he said, "There is not a word of truth in it. Not all men were created, only two were created, and one was created subordinate to the other." Calhoun believed that the Constitution was what he called a compact between sovereign states, which it emphatically is not. The Constitution, what do I do with my Constitution? Constitution says, "We, the people of the United States, ordain and establish this Constitution of the United States of America." The people of the United States. Doesn't say, "We, the states of the United States, will create a treaty between us that can be broken whenever we think that it's necessary." That's very different from the Articles of Confederation, which did say that. The Articles of Confederation explicitly said, "We, these states," and they listed all their little state names. It was stuff like Providence Plantation back then, "We, the states, preserving our sovereignty, create this Articles of Confederation," right? Now, those of you who have read The Federalist know that in Federalist 15, Hamilton says, the great weakness of the existing Confederation lies in the principle of legislation for states in their corporate or collective capacities as contradistinguished from the individuals of which they consist. That's probably the most important line in the Federalist. It's in Federalist 15, and it sets the theme for the entire Federalist. And what their argument was the Articles legislated for states, as corporate entities, and said these states are required to abide by these laws and these regulations and required to pay their taxes and that sort of thing. Did not bind any individual citizen. The whole point of the new Constitution was that it binds individual citizens. And the way Justice Kennedy put it, I'm not a big fan of Kennedy, but he put it really well in one case. He said, the founders split the atom of sovereignty. They said, from now on, you have two sovereign capacities, your citizenship in the United States and your citizenship in your state. And your citizenship in your state gives rise to certain state-related matters. Most things are handled that way. But when it comes to things like foreign affairs, you are a citizen of the United States, of the whole people of the United States, not a citizen of your state. And so that means that states are not parties to the compact. States are not parties or signatories of the Constitution of the United States. The Constitution was ratified by the people of the United States in special ratification conventions, not by their state legislatures. And Madison explained at the time that the reason for this was because we wanted to make sure that it was clear that people are not citizens of their state and through that of the United States. Instead, you are citizens of the United States separately from your citizenship to your state. And that means that states, of course, cannot intercede between the people and their federal government any more than the electric company can tell you, you don't have to pay your water bill this week, right? Because you owe separate payments to each, just like you have separate citizenship in each system. That's the quick and dirty rundown. Now, to get into in any more detail would take a great deal of time. I'll recommend that you all read my article, How Libertarians Ought to Think About the Civil War, in Reason Papers, that addresses this subject in much more depth. But that's just the quick and dirty answer. I would love it if nullification worked, right? Because, it would mean that we could resist the federal government. It's just not going to happen because it's not true. One other quick point is the idea is often traced back to the Virginia and Kentucky resolutions, which were framed by James Madison and Thomas Jefferson. What's interesting is Jefferson, in the Kentucky resolutions, said states can interfere because the Constitution is a treaty between the states. And he wrote a letter to Madison, and Madison wrote back and said, no, wait. He said, no, have you ever considered, he said, the difference between a treaty and the government of the United States? But by that time, Jefferson had already mailed off the resolutions to the Legislature of Kentucky. And Madison's resolutions are a lot more circumspect. He says states have the right to declare that laws are null and void, not that they have the right to annul laws. And because, Madison was always good at splitting hairs, right? So I would say, other than my article, I would recommend an excellent book called The Last of the Fathers by Drew Mccoy. Like Dr. McCoy. Drew McCoy's The Last of the Fathers, James Madison and the Republican Legacy, which has a wonderful chapter on how Madison, in the 1830s, decades after the Federalist Papers were written, was saying exactly the same thing. The Constitution is not a league between the states. The Constitution is a sovereign government of the whole people of the United States. Yes, sir.
There's a provision in the Constitution for a constitutional convention, whereby all of the states, and it recognizes states as individual actors, not people. And wouldn't have they just had a national referendum if it was really about individuals and not states as actors?
No, Marshall responds to that in McCulloch versus Maryland, where he says, sure, the people of the United States ratified the Constitution in their states, but not as states. I mean, at that time, first of all, how are you going to have a national plebiscite when you have no nation at the time, right? You're going to say, we're going to have the whole people of the United States vote on this thing. There is no people of the United States at that time, right? So, of course, they ratified them in special ratification conventions, which, by the way, if any of you have seen the Akil Reed Amar book, America's Constitution, a Biography, I keep recommending these books, but, I wish somebody had recommended books to me when I was your age. Akil Amar is simply the best writer on the Constitution, with the exception of our own Randy Barnett. His book, America's Constitution, a Biography, is the single best book ever written on the Constitution, with the exception of the Federalist. And he points out that, people nowadays say, well, the Constitution's so undemocratic, so only white men could vote for it, which is true. But the ratification conventions actually represented the broadest suffrage in world history at that time. Many people who could not vote for their own state legislatures were able to vote for delegates to the ratification conventions. It was the closest thing possible at the time to a people of the United States. Yes, sir.
I also am totally with you with John Calhoun. I would actually like to give you a comment on that. Doesn't the U.S. Constitution say that the federal government cannot favor one port over another, and that nullification would have actually favored the port of Charleston?
Oh, yeah, but there's lots of provisions of the Constitution that are like that. The most obvious one is the Republican form of government clause, right? The Republican guarantee clause says the federal government shall guarantee to every state a Republican form of government. Well, if secession and nullification and all this stuff were possible, that would simply be rendered null and void. Now, you might say, well, that's good, but remember that one of the big rules of legal interpretation is if your interpretation renders a phrase null and void, your interpretation is wrong, because people don't write things just that mean nothing. So, yes, sir.
If my state of Florida cannot opt out of this country...
Well, it never opted in.
Well, may I opt out?
Yeah, sure, you can give up your citizenship, certainly.
Well...
And states can leave the Union, as long as other states agree. Why? Because the Constitution guarantees the privileges and immunities of all the citizens of the United States, right? I have the privilege and immunity of traveling to Ohio. Ohio has no constitutional right to deprive me of that privilege. It is my right as a citizen of the United States. So Ohio can't secede from the Union and deprive me of that right, or deprive the people of Ohio of a Republican form of government, or break the law, which is the Constitution, by saying that no longer shall the people of Ohio be members of the federal union. Simply don't have that authority. So it's very complicated. Read my article. We don't have time for all this. Yes, back in the back. There's a property rights question. I can see it. I know I brought it on myself, right?
No, you can't. I'm Andrew Olson. I'm at the Federalist Society this summer. I took Akil Amar's class and had to read his book when it was still in manuscript. I didn't think it was that great. So my question is, are you telling me that the Civil War would have been fine if instead of having state legislatures secede, the people had set up special state conventions in each state and those conventions had seceded?
No, but secession would have been legitimate if... Now, see, I have an argument going on about this. I say secession would be okay by a simple bill passed through Congress. That if the entire Congress voted on a bill and got the votes necessary and approved and passed a law saying, from now on, Ohio is no longer a member of the Union, I think that'd be okay, but a lot of people say no, it would require a constitutional amendment, and I can see that argument. But my point is, states don't have the unilateral authority to do these things.
But surely the people, as citizens of the United States and also citizens of their state, can in some way get together and renounce their United States citizenship.
Sure, but they can all hand in their passports and say from now on we're citizens of Russia or whatever.
Right, but if the whole state of Virginia does it, all the people of Virginia together, does the federal government have some kind of claim on the land left over?
Well, in a way, you'd have nobody to operate it, but it would be a machine with nobody running it. Yeah, but it would still exist. The system would still operate, but there'd be nobody there running it, I suppose, if everybody in the entire state renounced their citizenship, which of course didn't happen in 1861. In fact, what happened in 1861 was that millions of people were kidnapped by whites masquerading as legitimate territorial governments, right? What you had was millions and millions of black people who were told that from now on they were no longer part of the United States of America. So, no more Calhoun questions. Any questions on property rights? Be happy to talk about Calhoun and stuff later. Yes?
Since we've gone down, I guess, the road to perdition in regards to property rights, where do you see us embarking on next on our journey?
If the people want to go to hell, I will help them. That's my job. I have no idea. I think that the backlash against Kelo, and there is one, it just hasn't been effective in the legislatures, but I think the citizens of the United States are very upset about this. I think what's going to happen is within the next generation or so, you're going to see, first of all, the whole idea of separate standards of scrutiny for property rights as opposed to other kinds of rights is going to unravel completely. It's already doing that. Roger Pilon, who works here at Cato, has a great way of saying it. He says, first we had rational basis scrutiny and strict scrutiny. Then we had intermediate scrutiny. Now we have skeptical scrutiny and heightened scrutiny for this and not so heightened scrutiny for that. And there's all these different scrutinies. And he says it reminds you of the Ptolemaic astronomers coming up with more and more epicycles to explain the orbits of the planets, right? We already are seeing the scrutiny systems falling apart. Grutter, which is the case where the Supreme Court said that racial balancing was okay in the Michigan Law School. In Grutter, they're supposedly using strict scrutiny, and then they defer to the government. You don't have deference in strict scrutiny. Well, that sort of thing is going to happen more and more as the system becomes unworkable. And then we're going to be faced with a real crisis, whether we are going to stand up for what the Constitution actually says and what are our natural rights, or whether we're going to give up on the project altogether. And I'm optimistic. I think what's going to happen is the backlash is already working. People who are entering law school right now are doing so with some really solid ideas. There are organizations like IHS and the Federalist Society and these other groups that are really helping to teach the true meaning of the Constitution. There are great books like Amar's and others coming out that I think are really going to help improve things a great deal. But, I was, in my dark nights, I worry about civil war. Not the Civil War, about another Civil War. Because when you see things like the red-blue map, you start to wonder about the cultural and social split in the United States. And I was complaining about this with a friend of mine. He said, Tim, no generation is more than 20 years away from a civil war. And that's true. I think what happens, what is a civil war about? A civil war is about when a people decides they are no longer a people, right? When some people say, we're no longer part of you. Our culture is different. The whole point of the Declaration of Independence, right, is to say, when one people dissolve the political bands that connect them with another people, we are no longer your people, right? I worry sometimes about cultural and social attitudes turning to the point where people think they are no longer part of the same country with those who differ from them. Now, I live in Northern California, where there are a lot of people who are very extreme in their politics, and some of them really do think that there's no talking to conservatives, and it's impossible to talk to them. I sympathize with that, I really do, but down that road leads some real problems. I don't think we're going to get to that point, because I think what's happening is we're having more conversations about these things, and organizations and institutions like this, I think, are really helping to improve the situation. So I think what you're going to see is 30 years from now, the Supreme Court will take another eminent domain case and they'll say, maybe we went a little too far in Kelo. We'll never get to the point that we would all like to get to. Just like there was never any golden age in the past, there's never going to be a day when we realize capitalism, the unknown ideal. But we are going to get to a situation where markets are freer, and we already have gotten to a situation where markets are much freer than they were in the past, and people are much freer. And I think that's very optimistic note. Yes?
So to give you your property rights question, you mentioned Berman v. Parker very briefly in your previous speech, and that seems to be the beginning of the whole eminent domain issue, where it misinterpreted the public use clause as public purpose.
Right.
And then after that, you had the Polltown decision, which just added more to the fire. But what was interesting was that just a couple months before the Kelo decision, Wayne v. Hathcock overturned the Polltown decision, and so it seemed to me that a lot of commentators were surprised by the Kelo decision. I wanted to get your take on why the Supreme Court actually differentiated itself from the Michigan Supreme Court there, and what the future of Kelo is going to be, given that there seems to be a misinterpretation of public use clause that could change if we were to overturn Berman v. Parker.
No, I see what you're saying.
Yeah.
First of all, for those who I did skim over this stuff real quickly because it gets a little technical, but in 1954 in Berman versus Parker, the Supreme Court unanimously held that the government can take property from some people and give it to other people for economic development. And that's been the law for 50 years before Kelo came along, and those experienced judges and lawyers were not surprised by Kelo. If anything, Kelo is remarkable for being the first time any justice of the Supreme Court has ever said that the public use clause limits government power. And that's true. We had 4 dissents in that case. Berman versus Parker, the first eminent domain case following the New Deal revolution, had no dissents. Hawaii Housing versus Midkiff, the other big eminent domain case after the New Deal, was unanimous. The Ruckelshaus versus Monsanto, a little talked about eminent domain case, was also unanimous on the point of public use. It was only in Kelo that we ever got a Supreme Court justice to say there are limits on eminent domain because of the public use clause. That's a great thing. And there was 4 of them who said that, right? So that shows that there is already solid intellectual foundation for changing the situation with regard to eminent domain. And, the Michigan case, what happened was in 1981, when were all of you born? 83? Oh my God. Okay, so in 1981, we had this guy named Ronald Reagan, right? And he was president. And there was a recession that hit the auto industry particularly hard. And the General Motors Corporation went to the city of Detroit and said, "We're leaving town." And the city of Detroit, the officials of the city of Detroit, being good defenders of public rights, said, "Please don't leave, please, please, please. What can we do for you to get you to stay?" And General Motors said, "Well, you could tear down that 400-acre neighborhood called Poletown because of the large number of blue-collar, working-class Polish immigrants who live there, and give it to us, and we'll build a Cadillac factory there." And the city of Detroit, of course, said, "Yes, master." And they condemned the property and it tore it down and built a Cadillac factory, okay? In a matter of months. And the Supreme Court of Michigan said, perfectly okay, because it improves the local economy, that's good for the public. Anything that's good for the public satisfies the rational basis test and is a public use, end of story. Well, after the Connecticut Supreme Court decided Kelo, but before the U.S. Supreme Court took the case, the Michigan Supreme Court overruled its previous Poletown decision in a unanimous decision, saying, this isn't good because if the government can do this, then you have the rent-seeking problem and so forth. I was very proud, actually, that my brief in that case was co-signed by the ACLU. It shows you that on this issue, like I said, the liberals are with us on this issue. I think that very much influenced the court to take the case. I think that's why the Supreme Court took Kelo. But it only takes 4 justices for the Supreme Court to take a case. You need to get 4 votes from the justices. Well, you got it from O'Connor, Thomas, Scalia, and Rehnquist, right? And then that wasn't enough to rule out in our favor in Kelo. So I think it exerted some influence. And I think it will exert some influence in the future. The Ohio Supreme Court last July rejected the Kelo theory and rejected the Poletown theory and said, no, public use really means public use. It doesn't mean benefits to public. It's the only state Supreme Court decision we've had since Kelo, but it's on our side, and that's really good. So, yes, ma'am.
Hi, my name's Rachel. I'm from the Institute for Humane Studies. A lot of what you were speaking about talks about already established property rights where people already have use of the land. And at our libertarian camp at the beginning of our summer, we had
I hate to be in a libertarian camp. All the guns.
We had free market environmentalism lectures, and I was wondering whether you've had any experience with the best examples, or whether you have opinion on what happens when we start, I guess, creating property rights in things like fishing.
Development rights.
I was thinking more like fishing in the oceans and those kinds of things.
Well, I think, from what I know about them, they're attempts to simulate a market system that are effective, from what I know, and I think are a good idea in general. One of the problems we've had with them is the idea the government is essentially just saying, okay, from now on, these are the property rights, and then you can shuffle them all around. And you have a problem with that with what's called transferable development rights, or TDRs, which we see in a lot of property rights cases. And we had a problem in one case. Gosh, it was one of these Lake Tahoe cases. We have a lot of those, where the government said, okay, we're going to use a Penn Central test to analyze whether a regulation is a taking, right? So we have our factors. Our first factor is what's the impact of the regulation, the character of the regulation. I might be getting these wrong. I never remember. And of course, there was the most important one. It was the impact of the regulation on discrete and reasonable investment-backed expectations, right? Well, they said, the government gave you these transferable development rights, and that reduced the impact on your economically viable use of the land, which means that it doesn't take 100% of the use of the land, and it means that the impact of the regulation isn't so severe, so you're owed no compensation. Now, the problem with that is transferable development rights are supposed to be compensation for the taking. Instead, what they're doing is they're using transferable development rights to decide whether there's a taking in the first place. And that means a property owner gets nothing, see? And so these things do tend toward abuse. But I haven't done many cases on those, so my general impression is that although they're subject to abuse, I think they are, certainly they're better than government rationing, right? Just about anything's better than government rationing. But I think that there are problems with transferable development rights, because if you're going to say, we're going to prohibit you from building another story on your building, and in exchange you get 5 transferable development rights. Well, why 5? Why not 6? Right? Well, because we're the government and we say it's 5. Well, there's your problem, right? Because then you've got to decide whether that's enough or not, because then they could say 3, and then they're taking. That's a taking, right? If the reasonable use is 5 and they say you get 3, then that's a taking of those 2 that they don't compensate for. So I think there are some technicalities that could cause and have caused some real problems. Does that clear everything up? Yes, sir.
Hi, my name's Arpin. Could you talk more broadly about the impact of environmental regulations on property rights, in particular like the EPA or the BLM or whatnot?
How much time do we have? The EPA stinks, right? Let me put in a plug here for what I think is the greatest movie of the 1980s, Ghostbusters. Greatest movie of the 80s, right? What's the message of Ghostbusters? Entrepreneurial capitalism will overcome the apocalypse itself. And the EPA is the bad guy. What other movie is there? The EPA? Well, it's true. The EPA really is the bad guy. One of the things is let's talk about 2 federal laws: the Endangered Species Act and the Clean Water Act. The Endangered Species Act requires you to get a federal permit if you're going to disturb an endangered species. One of the things I never tell you about is that species go on the list, they almost never come off. We actually, at Pacific Legal Foundation, got the bald eagle off the list these past couple months. Thank you. The species had recovered decades ago, but of course they didn't want to take it off the list. Why? Because they're concerned about the eagles? Of course not. Because the permitting scheme is a very powerful land use regulatory device, right? These laws were passed after an attempt at national land use planning was defeated in the Congress back in the 70s. And instead they enacted the Clean Water Act and the Endangered Species Act, which exist to require you to get permits, so it works just like federal zoning, see? And all they need to do is go out on your land and find an endangered species. In my neck of the woods, it was the Delhi Sands flower-loving fly. And once there is a Delhi Sands flower-loving fly population on your property, then you're required to get a permit. And of course, they don't give these permits out. I mean, it's years and a lot of money to get one of these permits. So I'm from San Bernardino, California. We had a hospital called the Arrowhead Medical Center that was halfway between my town of Rialto and the nearest hospital in San Bernardino. That hospital construction was held up for years because of the Delhi Sands flower-loving fly. Now, there are some people who did die because they did not make it to the hospital on time, right? Every minute counts when you're in an ambulance. So we know that at least one person gave his life for the Delhi Sands flower-loving fly, and to me, that is not worth it. I don't see why that is legitimate. And that's the kind of situation you run in with the Endangered Species Act. Clean Water Act, I think, even gets worse. All right, the Clean Water Act prohibits the discharge of a pollutant from a point source into a water of the United States. What is a pollutant? Anything, that's right, anything. We had a case where sunlight was a pollutant. Not kidding. The guy wants to tear down some trees. Too much sunlight will hit the stream, will disturb the fishies. Federal permit, right? What is a water of the United States? Anything, exactly. Any water that is, quote, hydrologically connected, end quote, to a water of the United States. Now you're sitting there thinking, wait a minute, does this mean when I go to the bathroom? Yes, there is no legal reason why you cannot be prosecuted for violating the Clean Water Act when you urinate in your toilet. We did a case called Rapanos versus United States. We represented Mr. Rapanos in the Supreme Court, and we think we won. One of those 4-4-1 decisions, or you don't know what it means, right? Where Mr. Rapanos owned land that was next to a ditch that connected into another ditch that connected into a stream that connected into a stream that connected into a water of the United States. And he moved sand from one corner of his land to another corner of his land. And he was not only found to violate the Clean Water Act, but he was sentenced to jail and fined millions of dollars for that. These are serious penalties, okay? So, unfortunately, federal jurisdiction extends to everything, right? And then they can say the discharge of anything from a point source, which means any discrete origin, right? As opposed to seeping out everywhere. Any discrete origin, anything that's not... Incidental fallback. Anybody know what incidental fallback is? Of course you don't. Incidental fallback is when you got a scooper, right, on the back of your bulldozer. You dig some dirt out of the water, right, out of the bottom of a riverbed. You got mud splashes over the side back, and that's incidental fallback. That is a discharge of a pollutant from a point source into a water of the United States. Fish guts from fish that get ground up in hydroelectric dams is a discharge of a pollutant into a water of the United States, okay? And people don't know about this because they think the Clean Water Act is about clean water, right? And it's not. It's about land. It's about dry land that is very far, in Mr. Rapanos' case, 20 miles from the nearest navigable waterway. And so it's being used as a federal land use regulatory scheme, which supposedly is not what it was intended to do. I think it is what it was intended to do, and it's doing it very well at the expense of property owners throughout the country. Now, in the Rapanos case, we got 4 justices saying, no, that's too far. We got Justice Kennedy saying, well, if I feel like it, then it's a water of the United States. No, he said, what was it? If it's got a strong nexus or something, I don't remember the words, then it's a water of the United States, and nobody knows what this means. So it's just going to cause more litigation, and we're going to go around and around about it. And of course, every time we win a case on one of these solid legal arguments, the left is going to go out there and say, they just want to kill bunnies. Because that's what we always get. I don't know if you saw the McNeil or the Lehrer NewsHour report about our bald eagle case. But, it was all about evil developers want to destroy Mother Earth, and they're starting with the bald eagle, even though it was the EPA that said that the eagle had recovered. They were the ones that were delaying taking it off the list. We simply asked them to get on with it. So of course, we just hate Mother Earth and all that sort of thing. So, you can't talk with some people.